opened by the representative of the Borno State Governor. I will go straight ahead to constitute the panelists for the commencement of the session proper. Let me respectfully invite to the stage Mr. Jonathan Sule Tadi, SAN. Mr. Jonathan was one time Secretary General of the Nigerian Bar Association and member body of benchers. Sir, you are most welcome. Other members to join him include our respected elder, one time Attorney General and Commissioner for Justice, Honorable Mohammed Manguno, ESQ. Sir, you are most welcome. I will invite another elder, Mr. Ayuba Nankam Damo, ESQ. Also to join them is my namesake, Mr. A.R. Abdusalam, ESQ, another elder. Thank you very much. We now invite the presenter, Chief Mr. Emeka Ibegolu, SAN. He is the chairman of the Remuneration Committee of the MBA. He doubles also as the chairman of the 2025 Enugu AGC and first Secretary General of the MBA. Sir, you are most welcome. I will now hand over the proceedings to the chair.
The chairman, NBA Maiduguri, and the counterpart chair, Bio Branch, our distinguished senior colleagues, the lead paper presenter, and the discussants here on this side. Good afternoon to Mark, who is the president of the African Bar Association. For reasons of some engagements, he's unable to physically come here, and therefore I was drafted to stand in. The fact that we have a judicial division of the Court of Appeal in Maiduguri, so that it can equip us. The 1999 Constitution has amended, and at the moment has 20 judicial divisions spread across the 6 geopolitical zones of Nigeria. The appellate court, as we call it, the first appellate court, as we call it, takes appeals from the State High Court, Federal High Court, Court Martial, Election Petition Tribunal, Sharia Court of Appeal, and so many other courts of record. So it's a very important first appellate court, and we are enjoying to take this session very seriously so that we do not get frustrated or would not get disappointed or embarrassed in the appellate process, because this is the very vital part that we must take note of. To deal with this very topical issue, the branches have put together the lead paper presenter and the discussants who are very vastly experienced in this area. So I enjoin all of us to pay attention with a view to asking questions at the end of the presentation. To have the first go is our lead presenter, Chief Emeka Obegolu, Senior Advocate of Nigeria. He's a bencher, past General Secretary of the Nigerian Bar Association, the President of the Nigerian Chamber of Commerce, Abuja chapter, and here he's also representing the Nigerian Bar Association President. So let's with a round of applause, invite our presenter to the podium. Welcome, sir. I have not been given any directives as to the number of minutes allotted, but I can assure you that he will do justice within a very short time.
Thank you so much. Jonathan Tomeetee, Senior Advocate of Nigeria and Chair of Session. For me, it's always a good thing coming back to Maiduguri, like I said earlier. I've seen a few of my very good friends who we are not seen for some years. Amina Ibrahim used to be our treasurer in NBA. It's good to see you again, Amina. Thank you very much. And of course, so many of you. I will start an established protocol to thank NBA branches in Borno State for the unique privilege of inviting me to speak to this topical issue. It is topical because for those of us in active litigation practice, if you do not understand the practice and procedure before the superior appellate courts, you will not be able to attain the rank of Senior Advocate of Nigeria. So I believe that the branch had this in mind when it framed this topic for the discussion. And I can only appeal to us to make this as conversational as possible, as engaging as possible. We'll expect questions from the membership, and I'm sure the panel will do justice to this issue. Nobody knows it all. I've prepared a 14-page paper, but having come back from break, I do not think I'll bore you with the text of the speech. But I started with introduction, like the chairman of the session has said, stating clearly the history of our Court of Appeal and the establishment starting from the Western Nigerian Court of Appeal to what is known today as the Court of Appeal, which was established by the Court of Appeal decree in 1976. Now, this court has contributed immensely to the effectiveness of the administration of justice in Nigeria. The court has also experienced several innovative developments over time, leading to what we have today as 20 divisions, including the Maiduguri division of the Court of Appeal. So they entertain appeals, whether criminal or civil, from Federal High Court, State High Courts, FCT High Court, National Industrial Court, Sharia Court of Appeal, Customary Court of Appeal, Code of Conduct Tribunal, Court Martial, Election Petition Tribunals, where they don't have original jurisdiction, Securities and Investment Tribunal, and of course, there's a bit of dispute whether appeals lie from the legal practitioners disciplinary committee to the Court of Appeal or to the Supreme Court. Opinions are divided, but we will not go there for now. Over the years, several rules of practice and procedure have been made by the various presidents of the Court of Appeal. That's why this paper will focus on the practice and procedure as at today, including the practice directions made portioned by the president of the court. Our focus shall be on the more recent rules made by the current president of the Court of Appeal, which include the Court of Appeal Rules 2021, the Court of Appeal Alternative Dispute Resolution Rules 2021, Court of Appeal Fast Track Practice Directions 2021, the Court of Appeal Practice Direction on Costs 2021, the Court of Appeal Exemption of Default Fees for Filing of Court Processes Practice Direction Number 1 of 2021, and of course the various practice directions for electoral appeals. These set of rules and practice directions regulate the practice and procedure of the Court of Appeal in adjudicating over disputes on the basis of its original or appellate jurisdiction. Now, on the civil appeal, the practice and procedure is extensively provided under Part 2 of Court of Appeal Rules 2021. But I want to call our attention to certain others that may be relevant for this discourse. Order 7 provides for the notice and grounds of appeals. Notably, under this order, all appeals come to the Court of Appeal by way of notice of appeal, filed physically or electronically. The notice must clearly set out the grounds upon which the appeal is filed and the particulars that set out the basis for such grounds. By Rule 3 of Order 7, vague grounds of appeal which do not set out in specific terms the basis for the appeal will be struck out by the court. So your particulars must set out in specific terms the foundation of your appeal. This is important. It is important to be concise and precise when drafting the ground of appeal. While the court is not limited to the grounds of appeal, the determination of the appeal, no argument can be made in respect of a ground of appeal that is not contained in the notice of appeal, except, of course, by the leave of court. Note that as Judge Will JCA pointed out in Tuko versus Maggi, the court has the power to strike out a notice for being incompetent, and may allow the notice where the incompetence is not a fundamental defect subject to rectification by the appellant. What this does is to give the court the discretion in certain cases in the interest of justice to allow for the rectification of minimal defects in the grounds of appeal. That was why what Judge JCA said is, this court has the plenitude of power to strike out a notice of appeal, as well as the appeal itself, if it turns out that the notice of appeal is not competent. This is so because once there is no valid notice of appeal, there is really no basis in law to proceed to consider and resolve an incompetent appeal. Judgment on the merits will be it having been reached in the absence of competence and lack of jurisdiction is nothing but a nullity. The judge went on to quote their favorite case of McFoy and UAC, when you cannot put something on nothing and expect it to stand. But like we noted earlier, you can always amend before you adopt your position, your premise, your proof of argument. Now, Order 8 is also interesting. It provides for the transmission of records. Now, there's a slight difference between the civil appeal and the criminal appeal. In the civil appeal, you are at liberty where the registrar fails to transmit record within 60 days. You are at liberty to apply to compile the record and transmit within 30 days. By the provision of Order 8.4, the appellant is expected to provide 10 copies of the compiled records and 2 encrypted compact discs of the compiled records to the Registry of the Court of Appeal. Upon compilation, the appellant is expected to effect service of the notice and record of proceedings on the respondent. Abubakar JCA, in underlying the effect of this provision in Cross-Country Limited and AG Mola, said that an appellant who has a valid notice of appeal like the applicant in this application must compile and transmit record of appeal. Compilation and transmission of the record to the Court of Appeal or the Supreme Court is the next stage. It is only when records are compiled and transmitted that an appeal can be deemed entered in the appellate court. And this explains why, when judgment is given, mere filing of a notice of appeal does not mean that the appeal has been tendered. So if you have a motion for stay of execution of the judgment, the moment you transmit record to the Court of Appeal, the trial court becomes status official. You can no longer entertain post-judgment applications. So for us, when you want to apply for stay of proceedings, you may delay transmission of record, stay of execution, You may delay transmission of record to allow the trial court to exercise its discretion whether to grant or not, because you have 60 days for the registrar to transmit. But the moment you transmit, you have forfeited a fait accompli on the trial court, in which case your application for stay of execution will now go to the Court of Appeal. The respondent is also at liberty where the appellant fails to compile record of proceedings. The respondent is also at liberty to apply for a departure from the rules to allow for the accelerated hearing of the appeal. If the respondent is dissatisfied with the record compiled, the respondent can also compile additional records within 15 days of the service of the appeal. Now, you know that when the registrar is compiling record, they invite both parties, counsel to both parties, or all the parties to come to verify the documents they are compiling. But when the appellant, pursuant to these rules, has decided to compile records, he compiles what he has and transmits. So upon service on the respondent will go through the record because he was not part of the compilation. So the rule allows the respondent to also submit or compile additional records. There are processes or exhibits that the appellant, for some reason, missed out in compilation. The respondent can furnish the Court of Appeal with these documents. After the compilation and transmission, the appellant is expected to make a deposit of 50,000 naira as a deposit for costs. Now, it becomes interesting that if after 90 days, 60 days for the registrar and 30 days for the appellant to transmit the record, the respondent, where the record has not compiled and transmitted, the respondent can apply to the court, and the court will strike out the appeal for want of diligent prosecution. Subject to the discretion of the court again to release the appeal where the appellant comes back with valid and cogent reasons why he couldn't or she couldn't file within time or transmit record within time. Order 9 provides for the filing of a respondent's notice of contention. A respondent's notice is filed when the respondent desires that the court varies the decision of the trial court in the event that the appeal is allowed in part or in full. A respondent's notice is also filed to request the court to affirm the decision of the court on grounds other than that contained in the notice of appeal. A respondent's notice of contention is to be filed within 15 days after the service of the notice of appeal in the case of an interlocutory appeal and within 30 days in other appeals. Now, there's a difference between a cross appeal and a respondent's notice. A cross appeal is, for instance, where you filed a case for breach of contract and the court found in your favor but awards you in damages a cost lesser than what you feel you suffered in damages. So you can file a cross appeal on the damages awarded. And the cross appeal, though dependent on an appeal, is also a distinct appeal. But when the court finds in your favor on grounds which you argued, and you also argued other grounds that the court did not uphold, you can now file a respondent's notice to urge the court to, in addition to uphold the appeal, also uphold it on other grounds. Now, why do you do that? Because you know that before the Court of Appeal, after the Court of Appeal, there is another court. So, if the court does not uphold all your grounds for the claim or your prayers, it is possible that when the Supreme Court strikes out any ground that is upheld, the whole claim falls. So you want the Court of Appeal by respondent's notice to affirm the judgment of the lower court on other grounds, including those that the lower court used to grant the judgment. So that is the respondent's notice. And it's Mukhtar JC clarified the essence of this notice in Alade versus Ogundele, when he said the citation is supplied, that the purpose of a respondent's notice is essentially to show and convince the Court of Appeal to affirm the decision appealed against on other grounds than those relied upon by the trial court. It is only the ground in the respondent's notice that may support an issue for determination. He went on to say other things. But under 10 of the rules provides for the filing of a preliminary objection, and it requests you to give 3 days notice before the hearing on appeal. However, as is the case these days, your arguments in support of your preliminary objection will be subsumed in your respondent's brief of argument. Now, when you get to criminal appeals, the rules are slightly different. It's provided under Part 3 of the Court of Appeal Rules 2021. Now, interestingly, Order 17 provides that an appeal may be brought before the court by ways other than the filing of a notice of appeal. So there's a discretion in the court to decide what constitutes a criminal appeal. So there's no strict adherence as to form. And that is why Banjoko JCA in Federal Republic of Nigeria versus Atuche said that the argument of the learned silk representing the third respondent that the appellant did not comply with the unambiguous rules of this court is misconceived and is inapplicable to the instant case, as this appeal is a criminal appeal, and the procedure for filing a criminal appeal is different from that of a civil appeal. The overriding guide in criminal appeals is that by the rules under Order 17, Rule 5, a proviso is stated that the court may, in the interest of justice and for good and sufficient clear intention to appeal to the court against the decision of the lower court, fails to file a notice of appeal or any of the other notices, the court may still entertain the appeal if satisfied that the intending appellant has exhibited a clear intention to appeal against the decision of the lower court. Where leave to appeal is granted, it is no longer necessary for the appellant to file notice of appeal. The court is liberal in allowing appeals to come to the court because in some cases, the life of a convict may be dependent on technicalities. So the court is liberal to allow appeals and to consider each appeal on merit. Now, for transmission of record in criminal matters, only the registrar is permitted to transmit record and has the power to transmit record within 60 days of the filing of notice of appeal. There is no provision for the appellant to compile and transmit record in the failure of the registrar to do so. In Abiodu and others versus Federal Republic of Nigeria, the Court of Appeal was called upon to determine the validity of a transmitted record of proceedings in a criminal appeal where the respondent complained that they were not summoned by the registrar before compilation of records. And EKJCA had this to say: the quarrel of the respondent who placed reliance on under 8 Rule 2 of the rules of this court is that it was not invited by the court below to participate in the compilation of record of appeal. Under 8 Rule 2 of the rules of this court is grouped under Part 2 of the said rules dealing with civil appeals, which start with Order 6 thereof. So it is inapplicable to the present application, which arose from the criminal trial, which is categorized under Part 3 of the rules of this court, starting with Order 17 thereof. And Order 17, 7, and 9 sub 1 thereof read together clearly shows the preparation of the record of appeal in the criminal case is the sole responsibility of the registrar of the court below, who does not need or require to summon any parties for the preparation of the record of appeal. Now, an appeal, again, criminal appeal, the Court of Appeal has power to grant bail, but where the appellant, who is on Court of Appeal bail, fails to appear, the court will decline to consider the appeal and proceed summarily to dismiss the appeal and may issue a warrant for the apprehension of the appellant. So I've also done a few points on the criminal appeal. I went on to appeal from court martial and other tribunals. The practice and procedure of the Court of Appeal in respect of appeals from court martial and other tribunals is extensively provided under Part 4 of the Court of Appeal Rules 2021. Order 18 of Part 4 thereof makes extensive provision for the procedure of the Court of Appeal in respect of appeals from court martial and other tribunals. The procedure are very similar to that of criminal appeals, except in the following circumstances. Court, where it's court martial or other tribunal, the Court of Appeal may suo motu amend the notice or grounds of appeal. So the court is not bound by the appellant's notice or grounds of appeal. In considering the appeal, the court can alter or amend the notice and the grounds of appeal. In determination of an appeal, the outcome from the Court of Appeal will be sent to the permanent secretary of the Ministry of Defense or other department of the government for the information of the authority responsible for advising the President on the exercise of the prerogative of mercy. Order 1484 provides for the savings of all proceedings, that is the saving provision. It provides that reference will be made to the Court of Appeal Act or other practice direction on anything that the rules do not make provision for in respect of appeal from the court. Now, a lot of technicality has been introduced to the Court of Appeal, particularly as it relates to the font size, spacing, pagination, the number of pages you file in your brief of argument. This is extensively provided under Order 19 of the Court of Appeal rules, because the rules provide that the brief shall be legible, well-bound, prepared in 210 mm by 297 mm paper size, that is A4, and typed in clear typographical character. The font size shall be in Arial, Times New Roman, or Latin of 14 font size, with at least 1.5 spaces in between. All brief of arguments shall not exceed 35 pages, except as otherwise directed by the court. However, a reply brief shall not exceed 15 pages, except on the court's technical grounds. Whether that means the justice is a question for another day. Parties with identical interests can file joint brief arguments or separate briefs where their interests are separate. Now, it is in election petition appeals that you see the interplay of these stringent requirements. Because the Court of Appeal has original jurisdiction over election petitions as to whether any person has been validly elected to the office of the President or Vice President, the term of office has ceased, or whether the office has become vacant. The practice and procedure of the court in respect of election petition is provided under the first schedule of the Electoral Act 2022 and the practice direction made by the President of the court pursuant to Section 142 of the Electoral Act 2022. In line with this provision, the President of the court usually makes a practice direction regulating the procedure for handling election petitions after each election. The most recent is the Election Judicial Proceedings Practice Directions 2023, which came into effect on the 22nd of May 2023. This direction made holistic provisions for filing briefs of argument, time of filing, the formal content of briefs of argument, as it relates to the election petition. It is important for those of us who are practitioners to get familiar with all practice directions in respect of election petitions so as to avoid pitfalls that may destroy your client's petitions. This is given the peculiar nature of election petitions and the timeliness in the dispensation of same. Let me put Idris JCA in Mahmoud and another as Mustafa and others. And listening to this, a pretty long cited quote. The appellant's brief of argument did not comply with the specifications in paragraph 11 and 14b and c, sub B and C of the Election Judicial Practice Direction 2023 for a brief of argument in election matters. And it gets more interesting. Paragraph 11 and 14b and c of the Election Judicial Practice Proceedings Direction 2023 provides as follows. The brief of argument which may be settled by learned counsel shall contain what are, in the appellant's view, the reasons upon which the argument is founded. The reasons should also be supported by particulars of the titles, dates, and pages of cases reported in law reports or elsewhere, including summary of the decision in such case in which the parties propose to rely upon. If necessary, reference should also be made to relevant statutory instruments, law books, and other legal journals. The parties shall assume that briefs of agreement will be read, considered in conjunction with the documents admitted in evidence as exhibits during the proceedings in the tribunal or lower court, and whenever necessary, reference should be made to all the relevant documents or exhibits on which they propose to rely upon in their argument. It goes ahead to provide with specificity the size of the font. Every brief must be prepared in 210 mm by 297 mm paper, A4, typed in clear typographic character, just like we stated earlier. Now, the court had this to say. Looking at the appellant's brief of argument side by side with the provisions cited above, it is clear that the said brief complied with paragraphs 11A and B, but did not. It is also clear, invalid. An invalid brief cannot support any appeal. In the circumstances of appeal, the appellant's brief, which is invalid, cannot support the present appeal. So no matter the merit of that appeal, no matter the law canvassed with the brief of argument, unfortunately, the Court of Appeal upheld the provisions of the practice direction that the brief cannot support the appeal. And what it means is that the appeal is unsupported and stands to be dismissed. Now, those of us who did the election petition, to be able to bring in all the authorities we want, what we started to do was to separate the list of authorities as another page. After we have signed within our 35 pages, we'll go and attach a different leaf, call it a list of authorities. And some smart Alex challenged it. They challenged that practice to argue that the list of authorities is part of the brief, and therefore the brief of argument has gone beyond 35 pages and liable to be struck out. And the court had this to say in Olatunde and another versus INEC. Ikek JCA said additional authorities in addition to the filing of briefs, not to elongate the brief, but to have the process standing on its own as aid for quick reference to ease the tedium of rummaging through the maze of a brief, which appears to be the case with some briefs filed in an appeal. The case of Ezani and Onyereri, Supra, cited by the third respondent is a point, where the Supreme Court held per the lead judgment prepared by Ogunmiji as follows. The Court of Appeal rules or the practice direction does not mandate the inclusion of list of authorities in the body of the brief. I agree with the court below that the brief was not irregular or invalid. The Supreme Court's decision in Ezani and Onyereri is a pointer to the position that the pages of listed authorities should not be computed or considered as part of the body of the brief and or in addition to the pages of a brief. The filing of brief is captured in paragraph 11 and 12 of the Election Judicial Proceedings Practice Direction 2023. Paragraph 12A thereof is on the filing of the respondent's brief. There is paragraph 14A of the Practice Direction to the effect that a brief of argument shall not exceed 25 pages. Normally, or usually, briefs are expected to be filed and exchanged before the appeal is fixed for hearing. Paragraph 15 of the Practice Directions stipulate that as early as possible and before the date set down for hearing of the appeal, the party who has filed a brief of argument or the legal practitioner representing him shall forward to the registrar the list of law reports, textbooks, and other authorities which learned counsel intend to cite at the hearing of the appeal. The list of authorities mentioned in paragraph 15 of the practice direction is not in any way a continuation of the brief. It is not subsumed in the brief. It is a separate process and not an extension of or appendage to the brief. It comes after the brief has been filed and not with the briefs. Timeline for both is also different. Likewise, the preliminary objection to the length of the third respondent's brief. So what the court is saying here is that the pages containing the list of additional authorities would not be computed in calculating the pagination of a brief. And I said in conclusion that a good lawyer knows the court. When we say that a good lawyer knows the court, some people perceive it negatively to mean that a good lawyer knows the judge, you go and meet the judge after the court. But I see it differently. That a good lawyer knows the court, that a good lawyer knows the judex, he knows the temperament, the nature and nurture of the court, and to know how to approach the court to get favorable rulings. And I'll give you an example. As a young man growing up in Abuja, we had this judge. Those were the days before filing of written arguments or written address. Those days you come with your authorities and cite them, flag all the authorities, cite them, and the court will record in long hands. So, because we know the judex, any day you're not ready for your matter to go on, you come and pack authorities on the table. When the judge looks up and you see that your table is filled with law books, he will say, Mr. Opegolu, this your mother cannot go on today. Can you take it? Because we know the judex. So, knowledge of the court is very important. In the court of appeal, you must know the presiding judges who entertain adumbration and those who don't entertain adumbration. If you go to court because last time you had a hearing, the court didn't allow you to adumbrate, perhaps this time you didn't waste your time to prepare for the hearing. And learned counsel on the other side says to the court, my lord, can I take 5 minutes to emphasize on some points in this brief? And the court allows him. What it means that you're entitled to 5 minutes. And if you're not prepared for it, you will falter in adumbrating your brief. No matter how well you prepare the brief, you don't read it the night before the appeal, you cannot adumbrate on it. So it's always good. My practice is to read for every appeal as if I'm going to be allowed to adumbrate. You lose nothing if the court says just adopt and move on. You lose nothing. No knowledge is wasted. A legal practitioner who is desirous of having a successful appellate court practice, it is imperative that you understand and have a thorough understanding of the practice and procedure of the court in respect for all types of appeal. As a court of record, the Court of Appeals practice and procedure in respect of all appeals is highly regulated by the rules and practice direction. The court will not deviate from the provisions of the rule except it is established that there is a strong justification for doing same. As such, any legal practitioner that must appear successfully before the Court of Appeal must have a thorough understanding of the rules of practice and procedure. There are so many benefits therefrom. In conclusion, a successful appellate court practice is a rewarding experience for legal practitioners. The first day I appeared before the Supreme Court, it was like elixir for me that I could address 5 justices of the Supreme Court as a young lawyer. So every lawyer wants to have, particularly for those of us who have chosen litigation, we want to have an experience before the highest court in the land, from the appellate court to the highest court in the land. To achieve this, it is imperative that in addition to the in-depth knowledge of the law, the thorough understanding of practice and procedure is required, because the practice and procedure that aids the presentation of your case in a manner that will persuade the justices to allow or dismiss the appeal. As such, you are required to spend time reading through the rules of the court and various practice directions to be equipped in the appellate courtroom practice. And you also need to be updated with current changes. In 2023, when the 2023 election tribunal rules was promulgated by the President of the Court of Appeal, a lot of lawyers who were filing appeals did not know about it. So there were so many victims of these technical grounds because not many lawyers who were doing election petition knew about it. Because those of us who were in Abuja were fortunate to be part of the unveiling. But when people brought appeal from different jurisdictions, we were able to successfully knock it out for failure to comply with the provisions. It is my belief that this overview on the practice and procedure of the Court of Appeal will serve to whet your appetite for more understanding and experience. And I have no doubt that the gentlemen who have been assembled today to do justice to this topic will complement or may disagree with me, all to the greater knowledge of our members. And as much interaction we have from the floor, we will also gain some knowledge. Thank you very much.
Thank you very much, our lead presenter, Chief Emeka Obegolu, JP. My lords, our distinguished colleagues, you agree with me that the lead presenter has given us an overview, or what I like to say, call the expo, that if you pay attention to, you can approach the appellate court successfully and also sustain your appeal. No counsel wants to be in court and be faced with the misfortune of having his or her appeal struck out on these grounds of lack of compliance with the procedure on the day the appeal is fixed for hearing, particularly if you have spent a lot of time waiting for that date. So it's very important that we pay attention to the highlights in the general paper when circulated. Thank you very much once more, and let us give him another round of applause for the efforts he has put in. Now, the organizers have assembled discussants to share with us their perspectives on this very vital topical area. In no particular order, let me invite our senior N.A. Damo Esquire. He's sitting to my immediate right to share with us his perspectives. Either agree or disagree, but I know he will agree with the lead presenter. You have the floor for 10 minutes.
Thank you very much. Thank you very much, Mr. Chairman. My Lord, the Honorable Chief Judge of Borno State here, my Lords, Judges of the High Court of Borno State and the Qadis, my colleagues. I agree in toto with everything the learned silk delivered here. He gave us what the rules of the Court of Appeal provides and how we are supposed to apply while practicing in the Court of Appeal. He has given us and gone ahead to trace the history of the establishment of the Court of Appeal from 1976 to present day. Like he said, the practice and procedures in the Court of Appeal has undergone several changes with many rules. The extant rule being the 2021 rule. I agree with him in all that he has said here, but I'm concerned with what we do as counsel before the Court of Appeal. He has touched part of it. You must know the judge or the judges, the antecedents. He has given us his experience. Yes, as counsel appearing before the Court of Appeal, first and foremost, you must know the rules and procedure. You must know the rules. You must be versed and conversant with the rules. Apart from that, you must know your law. Many of us fall foul of this aspect of our practice. And you will appreciate the reaction of justices of the Court of Appeal sitting Maiduguri here. Some of us say they insult us, they abuse us. It's because many of us do not go in the Court of Appeal. It is necessary for us to also know the fact that once we are appearing before them, your file. Many of us do not even know our files. Once our cases are called, we get choked up when the justices ask, when did you file your process? Where did your, what date did you file your process? We get choked up. So it is necessary for us to know our files. When you file your notice of appeal, when the record of appeal was transmitted, when your appeal was entered, and when you filed your brief of argument. The presiding justice here will always insist on all of these details, failing which your appeal is always struck out. We have that experience, all of us here. We need to know our files. Most importantly, too, when writing and presenting, writing your brief, we must be careful with the language we use. Many of us use foul language, condemning judges of the lower court, as if that is enough for us to get our appeal allowed. No. We shouldn't. I'll never forget it. Justice Kuyasemi of blessed memory will always tell you, know the judges you appear before. Like the lead presenter said, know your judge. If you know your judge, you know what he wants. You know how to present what he wants. And you will never have problems. My friends, it is necessary for us to do that. To know our judges, to know the courts we practice in. Now, it is important for us commence proceedings in the Court of Appeal, and there must be valid notices. There must be valid notices. I had the experience of filing a notice of appeal without the relief being part of it. My appeal was struck out. My notice of appeal was struck out because there was no relief included therein. On a second occasion, I had the luck of getting the appeal allowed, but then I had a whipping by one of the justices in the judgment, condemning and advising properly what the need for us to have included a relief. So whatever you require should be contained in the notice of appeal. And that way we will be able, your notice of appeal will be seen as valid. Do not ever assume. We are therefore required to be focused in our write-ups, presentation of our cases before the Court of Appeal, and properly dressed. Thank you.
Thank you very much, Mr. Damo, for your perspectives. I saw with emphasis 3 key points that he made. The first, that we know our rules. You don't put on the table the 2016 rules in 2025 when you're preparing your notice and grounds of appeal. Certainly, you will miss out very vital innovations in the 2021 version, such as front-loading, etc. So know your rules. The other point is know the facts of your appeal. So you don't go before their lordships and they ask you, what are the facts of this leading to this appeal? I say, oh, I just got the file this morning or last night and I haven't looked at it. I was asked to only come and argue the appeal. You know, it will be very embarrassing that you just stand there shivering early in the morning. If their lordships are in a very good mood, they may even ask to offer you a cup of coffee just to cool you down. The other point is ethical practices. We must learn in arguing our briefs not to use derogatory words in describing the lordships whose decisions were brought before the appellate court. We must accord due respect to their lordships in our arguments and in our conduct throughout proceedings as legal practitioners. Once more, on your behalf, I ask that we give him a round of applause for sharing those insights with us. Now, let me move to my extreme left and invite A.R. Abdusalam Esquire to share with us his perspectives.
my Lord, Honorable Chief Judge of High Court of Borno State, and judges of High Court of Borno State, and the other protocol duly observed. The topic chosen today is tally with the establishment of Court of Appeal Division in Maiduguri. Although before the coming of Court of Appeal Division, Maiduguri Judicial Division here, we have been having sitting Court of Appeal. We have been assisted by Court of Appeal coming here every time. And when we appear before them, they always agitate on the rule of Court of Appeal that it seems the lawyers in the Northeast have not familiarized themselves with the rule, particularly in the area of compilation and transmission of records. And if we look at it very well, there are some inherent provisions in this rule that we have to take care of, particularly, again, if your record of proceedings is transmitted out of time, you have to regularize. There is a recent provision of the rule that says it cannot be deemed, your record of proceeding cannot be deemed compiled and transmitted on the day your application is granted. It has to be deemed 90 days to the date your application was brought, argued, and granted. So, in view of this, my learned colleagues, which means you are automatically out of time in filing your brief of argument. So you have to pay default fees of about 100 or 200 plus for the default fees. So in this way, please let us know that we have to compile. There is mandatory compilation. Actually, we have challenges in Borno State when there was flood and some other issues of compilation and transmission of records of appeal. So, in this wise, mandatory compilation by the appellant has been provided in Court of Appeal 2001 rule. So, if it has not been compiled by the registrar within 60 days, you have to make haste to compile it within 30 days so that you will not be going for regularization of your compilation and transmission of record of appeal. So then more so, we have to note that in the new rule, that it has become a problem between counsel and the court recent, that you have to show your receipt of payment. So that area, we have to take note of it. Then, if the filing or your brief of argument fall If your brief of argument falls within vacation period, then that vacation period is not reckoned with in filing of a brief of argument. So, also, I would like to call our attention to this Court of Appeal Fast Track Rule 2021, Practice Direction 2021. There are some appeals that exempted and are under Fast Track, Court of Appeal Fast Track Practice Direction 2021. And these are like debt appeal, cases in FCC, ICPC, some other criminal cases like terrorism, kidnapping, human trafficking, and money laundering. If you have these cases, and human rights, that is the area I want to go. Human rights issues. So you have, it's not the main Court of Appeal rules that applies. It is Court of Appeal Fast Track Practicing Direction 2021 that applies. And only brief dominates that direction. That is, in case of appellant, you have to file your brief within 14 days, while the respondents within 10 days, and reply brief within 5 days. Please, let us look at our rules, read them, and so that we will not be having challenges with Court of Appeal judges, because of recent they have been complaining bitterly about some of our handling of these cases. Thank you very much.
Thank you so very much, sir, for sharing with us your insights. My lords, distinguished colleagues, you agree with me that he has emphasized on 3 key points. The first being the need for us to familiarize ourselves with the rules of court, so that where you are out of time, either in terms of compilation of records or filing of brief, you take steps to ensure that you have a motion, an application to bring your process in appropriately. And also the issue of computation of time, so that when you're out of time, you know that relevant penalties apply. And lastly, that we take keen interest and know that there's a fast-track regime embedded in the 2021 rules of the Court of Appeal. We're grateful, and I want you to once more applaud him for this intervention. Now, permit me to invite our former Attorney General, a seasoned practitioner, Honorable Mohammed Mongonu Esquire, to share with us his insights. Thank you.
My Lord, the Honorable Chief Judge of Borno State, Honorable Judges and Cadis of Borno State, my dear colleagues, I should also mention members of FIDA. I recently acquired a certificate on gender-based violence, so I always try to recognize FIDA wherever I go. We are very lucky this afternoon to have in our midst most likely, I would say, most likely, I repeat, the future presidents of our association. Chief Emeka Obegalu, SAN, and the man who is always tidy will definitely serve the bar in the capacity of presidents of the Bar Association. Not forgetting our own second AFAM, who chaired the very bubbling, dynamic and active Abuja Bar. I am happy to see you here in your home. Now, my own take here starts with, why do we even have a court of appeal? Prior to 1976, there was no court of appeal. Appeals from the High Court straight went to the Supreme Court. I just want to cite one case in which Abdul Salam is involved later on, the case of Hajia Adama and Umar Ali. From here, it went straight to from the High Court of Northeastern State, it went to the Supreme Court, and judgment was delivered by the Supreme Court, presided by Elias CJN. So this simply takes us to the pivotal place occupied by the Court of Appeal in appellate jurisdiction in our country. Now, if an appeal is coming against the judgment of high courts, federal high courts, National Industrial Court, court martial, and several other tribunals, then you have to be ready. These are highly competent and experienced judges, and you want to set aside or reverse their decision, then you have to be ready for it. It's not a walk in the park that you come fresh from law school and then you say, I will appear before the Court of Appeal. You have to learn the ropes from those who were there before you. And I think that is very, very advisable. And that probably was the reason why our division here has been complaining for some time. But then, even Lagos started that way. It's not an overnight thing. I, for the sake of saving our time, had already prepared a paper and shared it on my website. I've shared the bar code to the chair of the organizing committee as well as the chairman of the bar. So kindly go and download the paper. For the next 7 days, it will be there. Thereafter, it may be something else. I may probably start asking for you to pay for it. Cheslawchambers.com, you will get my paper there. I reviewed extensively because initially I was with the impression that I'm coming to do a presentation. Then later on I heard that I will be a discussant. But in today's Nigeria, when you are called to be a discussant, you are as well in the same shoe of the presenter. So I'm not running away from that responsibility. But then, let me start by saying that in my paper I reviewed the jurisdiction of the Court of Appeal. I reviewed the powers given to it under Section 239 of the Constitution, their original jurisdiction on presidential election matters to determine the vacancy of the office of the President or Vice President. I also went further to determine other jurisdictions conferred on it under the Constitution. So they have original jurisdiction as well as appellate jurisdiction. Now, you further break down the appellate jurisdiction into appeal as of right and appeal with leave. For sake of time, I just need to mention one. Appeal on leave will be appeals like coming from National Industrial Court. you first have to seek leave of the Court of Appeal, and then when you obtain the leave, before you can even file your papers. So I reviewed several other scenarios in the paper. For ease of time, I will not go into them in detail. Then, when you are appealing against the decision of a high court that sat on appeal, not as a court of first instance, you also need leave to appeal in most cases. It is only when the matter touches on death penalty that you have a right of appeal straight ahead, or when it is purely on question of law, you have a right of appeal. Then the other scenario I considered is court-martial. Because of our situation here, we have a court-martial here for some time. Now the question is, when do you appeal? What are the timelines for appealing? I reviewed that briefly in the paper, and thankfully, Leonard Sikh Emeka Obegolu has touched on that as well. When the court-martial decides a matter, it is not the end of the road. It has to be confirmed. So if that judgment is confirmed by the military authority, it is still not end of the road. They have to do what they call promulgation of the sentence. It is upon promulgation that your right to appeal will now arise. But in most cases, you'd find a situation whereby the advocate who appears in the court-martial will always recommend that there could be a room for appeal. And then the Court of Appeal usually deals with areas having to do with errors of fact and law, or errors in procedure of the lower courts. So it is an opportunity to give you another chance to attain justice. And so that is principally the purpose. Judgments of the trial courts are done by human beings, and there are bound to be errors once in a while. And it is for correcting such errors that we have the Court of Appeal. Now, apart from that, I also considered the innovations that we have under the current rules of the Court of Appeal. There are several innovations that have been introduced against what was obtainable under the 2016 rules. So the 2021 rules introduced about 10 of such new innovations. One of them is the Court of Appeal Alternative Dispute Resolution Center. A lot of our colleagues exercise the fear that when I have an opportunity to take credit of having my matter determined by the Court of Appeal, and so I will count one completed judgment, why should I resort to a window for arbitration? Wrong, because the practice is that at the end of the ADR proceedings, they come up with what is called Memorandum of Settlement. And so that Memorandum of Settlement will be forwarded to the main court, and counsel will now come and adopt it. And that adopted memorandum becomes a judgment of the Court of Appeal, and so one complete case for you. So there shouldn't be any fear. In situations where you feel that parties have the capacity to settle, please do encourage. Professionally, we are encouraged to do so. Another aspect that I picked is the introduction of new technology, which is within the theme of our Law Week. What are the technologies introduced? Virtual hearing, where that is possible. The justices of the Court of Appeal may opt to do a virtual hearing, and then also deliver virtual rulings or judgments. That is there to some extent, but it has not gone far. It's not as far as the practice here in Borno State, where our high courts routinely have been doing virtual proceedings for some time. And then there is this new innovation of having 24-hour e-filing. If it's 24 hours, it means 24 hours. But the registries don't operate it that way. They don't have the technological infrastructure to run it. If it's 24 hours, it should be 24 hours. That was the time I came here to file papers within time, only to discover that there was Jusun strike. I waited. Jusun called off the strike. I was still within time. And then the registry was not there. They'd already closed and gone home. That Salah was coming. And they have to go and look for their rago. You can't blame them. So that is a very good innovation, but it's not practically implemented. So I think we have to keep eyes on that and push for that to be practicalized. Another innovation, although Chief Emeka mentioned that where the appeal has been entered at the Court of Appeal, then the lower court can no longer entertain anything having to do with that matter. I think that is wrong. I disagree with Emeka because the new rule provides that if it is not impacted, if the proceeding is not impacted by what is on appeal, the lower court can still do it. And I witnessed that before Justice Eko of the Federal High Court in Abuja. That Zaki Biam matter, CBN was a garnishi. CBN, instead of them to pay what was already a garnishi absolute, they were dancing around it that we have appeal, and because the appeal has been entered, the Federal High Court can no longer entertain the matter and what have you. Just Eko said, who told you that? He said, I have a motion for that. Please move your motion and I will dismiss it. And so he did. He said, what is the... So he said, what has a garnishi got to do with asking for a stay? All that you are asked to do is, there is XYZ funds in your account. Deliver it to the court. And then you say you have appeal against that, which the Supreme Court itself has frowned on. So his appeal has not impacted with the orders given by the court, by the lower court, the trial court. So I think, Chief Emeka, maybe I'm wrong, but please try and look at it and further refine this point for us. The other aspect that I also touch on deals with the timeline, which my colleague Abdul Salam has mentioned. Timelines within periods of vacation or pandemic based on the practice directions will be frozen. So we should take advantage of that and discount the number of days falling within those periods. When you have 45 days to file appellant's brief of argument, and then 30 days out of the 45 fall within public holiday, pandemic, and what have you, you have to discount that period. Or there is a labor strike like Jusun and what have you, you have to discount those periods. So that is also there. Then more of these new innovations are all captured in my paper. I'm so sorry for sake of time, but I encourage you, I urge you to kindly look at the paper. I reviewed all of this and then enjoy it. Thank you very much, sir.
Thank you very much, our leader, Honorable Mohammed Mongodu Esquire, for your interventions. He has raised an issue, an area of disagreement with Chief Emeka Obegulu. As practitioners, Chief Emeka has a right of reply, so at the appropriate time, he's going to respond. In summary, the discussant has said that his paper is online, and enjoying the organizers to take advantage, download, and probably share to all registered participants so that you don't have to pay for it after 7 days when it has been taken off. The other issue, so that we don't sound repetitive, is the initial point he made. A practitioner who is challenging the judgment of a trial court has to be diligent in all respects, so that you don't end up with an appeal process that's having K-leg. You know, the man who is complaining that the judge did not do justice to the matter now ends up having his own appeal be rendered incompetent. That would be very suicidal. So let us pay attention to these procedural rules so that we have competent appeals. On this note, I ask again that we give a round of applause to the lead presenter and the discussants for a job well done. Now it's time for question and answers. I don't know how many questions we can take. Maybe we'll take one from this row, another one from here, and but before the questions, Chief Emeka, our lead presenter, will clarify the earlier point he made.
Thank you, Mr. Chair, and thank you, Past Attorney General. Now, when I spoke about the appeal, it was in the context of stay of execution as a post-judgment appeal. Of course, we enjoin courts, and some courts are courageous to continue entertaining proceedings even when an interlocutory appeal has been filed and record transmitted. The reason is because some of our colleagues now utilize the interlocutory appeals as a weapon against other parties in the proceedings. So they use it to frustrate proceedings. So I, as a matter of course, I encourage courts to continue until there is an order for stay of proceedings by the Court of Appeal or the court handling the matter. But where it is a post-judgment proceedings, as soon as record is transmitted, the court becomes seized of the matter and has to wait until the Court of Appeal determines it one way or the other, particularly motion for stay of execution or any motion whatsoever that is post-judgment. And I want to also thank him for bringing up the issue of the ADR rules of the Court of Appeal. Now, sir, yes, the settlement will be entered as judgment of the court, but the problem arises where you go to apply for the rank of SAN, and the provision, the guideline says contested cases. And that is where the LPPC will begin to look at your judgment, though obtained from the ADR Center of the Court of Appeal, and they will classify it as uncontested. That is where the problem is. So I think we should rise from this platform to begin to ask for changes in the guidelines for the rank of Senior Advocate of Nigeria, so you don't meet that bottleneck. Judgments of the Court of Appeal, particularly where parties have filed and exchanged their briefs and subsequently gone for settlement and settled, should qualify for reckoning when you apply for the rank of Senior Advocate. I don't see why not. But as at today, as I put it anyhow, as at today, it does not count in assessing your qualification for the rank of Senior Advocate. So perhaps from this, communicate from this law week, should urge the Privileges Committee to tinker with the guidelines to allow appeals or judgment from appeals where briefs have been filed and exchanged and parties go for ADR or settlement and achieve settlement. Because what it does for the system is that it will also reduce the docket of the Court of Appeal, encourage lawyers to go for ADR. As it is today, like you are clearly identified, lawyers are not willing to subject themselves because particularly those who are intending to use the appeal judgment for the rank of Senior Advocate of Nigeria. Thank you very much.
Thank you very much, sir, for your intervention. And before we go to the floor, my Lord, the Chief Judge wants to make an intervention. Can we quickly have my Lord? We have my Lord with time limit. That is the order of the panel.
Thank you very much. Somebody knows me up there, so they're imposing a time limit on me. I will be as fast as possible because actually I thought deeply whether I should intervene or not. But from Monguno's submission and in fact, from all the panelists, I think it's better to point out this, how technology shall impact the Court of Appeal rules. And for me to do that clearly, I want to dispel or bring to the attention of everybody that technology is not implemented in Nigeria without a policy. Maybe some of you have already heard of JITPO. JITPO means Judicial Information Technology Policy. That was enacted by the National Judicial Council in the year 2012 by Justice Mustafa. And there is a committee implementing that policy. And that is the committee that I chair. And what has happened in Borno is not a Borno initiative 100%, no. It is an implementation of that policy. The same thing took place in Delta, the same in Bayelsa, and last week what took me to Lagos on Friday is for the Federal High Court to start implementing that policy. We have a federation in Nigeria, powers are divided. NJC has developed the software across the courts under its own, so to speak, jurisdiction by the provisions of the Constitution, providing whereby it says the recurrent expenditure of the courts, superior courts of records, shall be a charge on the consolidated revenue fund of the federation that comes through the NJC. An interpretation of that led to the now development of the technology for those superior courts. Those in Borno should know, when you go to file e-filing, what you see on a drop-down is a complete national judicial sub-infrastructure. It's not fragmented. The whole idea was to come up with a complete infrastructure. That is why as soon as all the courts on board, you will see on the drop-down Supreme Court, Court of Appeal, then courts of first jurisdiction, Federal High Court, National Industrial Court, and then the state courts. And you click, the moment you click on one court, the rules of that court automatically apply and it blacks out the rest of the courts. And that is what is being implemented now. It is not haphazard. Now, power to make rules belong to the different courts. So once they implement, then they make reference to the NCMS, the Nigeria Case Management System, and its e-filing platform, and by reference adopt these things, the filing format and everything that goes with it. Now, once that is done, they are on the platform and it is a national infrastructure. How would that impact the Court of Appeal rules? Let me now come to this session. Number one, we have heard about the briefs, pagination, spacing, and whatnot. Some of these things will become obsolete, and the rules will now have to be made by that court to reflect the electronic format. All these rules of spacing and this thing were a function of the paper-based filing. Rules will be made by that court to conform now with this. A lot of it will just go away simply because the format of converting to PDF and filing will automatically eliminate the stress of reading. And particularly now with the bar, and that is one of the reasons why I said I should make this intervention, is the one obstacle that is remaining for us to have a completely digitalized creation of records by lawyers and filing. Because for them to affix that manual stamp, it has to be on a hard copy document before they scan and upload. Already it has started. I saw some, I think Law Pavilion come up with it. We have given options to the MBA to come up with a digital stamp. Once that is done, it's a matter of now any lawyer creating a document, creates it in Word, converts it to PDF, affixes his electronic signature, which again I have to dispel the impression that it is not allowed. The Notaries Public Act 2023, signed into law by the current president on the 12th of June, now makes that valid. So Apart from the 2021 rules, we have a newer one of 2023, which makes electronic signatures valid for use in the courts. Now with that, there will be absolutely no need to worry. Everything starts and ends on the desktop of the lawyer. He creates the document. Scanning will only come into play where, let's say, a contract was signed outside in hard copy, and then he will now have to scan and upload it if he wants it as part of his exhibit. Compilation of records of appeal. Again, that when the stress was going on, I was just smiling to myself. 2 months, no, about nearly 5 months ago, we presented to the Court of Appeal the state of readiness and that they should start now also on the NCMS. Once the Court of Appeal comes on board, the Supreme Court comes on board, this question of compilation of records will become absurd. Whatever record an appellate court needs in order to hear the appeal, so long as that state or that court goes to the court, cases were being filed and assigned. So I think I must have already violated the time limit, but I can see from your expressions that it is time well spent. So I don't want anybody going away with the wrong impression that we do not have a national policy that we are implementing. It's since the year 2012, there is a policy. Go online, Edo State Judiciary has even uploaded it. There is a PDF of it. We have actually even reviewed the policy, and very soon the CJN is going to launch the reviewed policy. So there is a policy being implemented, and nobody is being left out as far as constitutionally, because all the courts are entitled to it. What Borno has, every high court in Nigeria is entitled to it. All other superior courts can come on board. So nobody is going to be left out. And a lot of the pains that you are having now will be a thing of the past. Thank you very much.
Thank you very much, my Lord. It was indeed time well spent. Now we have two hands. Questions, 1 minute each. Yes, you can come forward. And the third on this line, and I'm sure, please direct your questions to either the lead presenter or any of the panelists. 1 minute and your time is already running.
Thank you very much. Since it is 1 minute, all protocol duly observed. The lead presenter, Lana Silk, will agree with me and the entire panelists that the Supreme Court, and in fact all courts in this country, have discouraged technicalities. My own question, considering Order 8 of the Court of Appeal Rules 2021, that if you are out of time to transmit a record, you cancel after 90 days, you file a motion for extension of time to transmit record. If you file the motion today, and unfortunately the Court of Appeal did not hear the motion until after 2 years, on the day that the Court of Appeal had the motion, they will deem it on the day 90 days, meaning you have 2 years now, you are out of time 2 years. For you to file appellant's brief of argument, you need to pay penalties for 2 years. You'll file motion for extension of time to file appellant's brief and pay penalties for 2 years. The question now arises as to whether this is technicalities or it has helped the litigants. Thank you.
I think we'll take the other questions so that our panelists, discussants, we respond at the same time.
Okay, sir. My question is very simple. Like one of the trial court judge was saying, if you
Can you identify yourself and then?
I am A.S. Badagubi. Like one of the trial court judge erred in law, and you give the particulars of the error. Now, if you agree with that, we want you to explain what it means by saying the trial court judge erred in law, and also the trial judge misdirected himself in law, so that we'll avoid drafting vague grounds of appeal. and equally will know the exact cap that will put on the head of that judge.
My Lord DCJ, all protocol observed. My name is Modu Grema. I have one observation and one question at the same time. We have the court martials in Maiduguri that are operative due because of the insurgency to file an appeal against